Let me introduce myself. My name is Renee Brooker. I feel like a newscaster up here, by the way. I've never sat in one of these tall chairs. I feel like I'm gonna report on the news, but I would love today to be a dialogue. So I don't really want to just talk at everyone. Please feel free to, weigh in, disagree. There are things that we all may say up here that we disagree with one another, or you may disagree with us, or think that we have pie in the sky ideas or ideals about the work that we do. So my name is Renee Brooker again, and I spent 26 years in government up until 2017. And most of my time in government was spent in a leadership role at the Department of Justice, overseeing the False Claims Act and the U.S. Attorney's offices in the 94 districts that have False Claims Act cases and enforce the False Claims Act. And so the office that I came from in Main Justice in the civil division is a very large one. We probably have 200 people on a good year when we have our numbers up, which includes probably, somewhere between 160 to 180 attorneys like me who enforce the False Claims Act, and then a variety of support staff there, from auditors to investigators, to paralegals, to, physician, to financial analysts and the like. So it's a big operation at the Department of Justice enforcing the False Claims Act, and I loved it with a passion. So once I moved into that part of DOJ, which is not where I started, I had been in 2 other places doing tobacco litigation, the racketeering case against the tobacco industry, and I had also handled savings and loan crisis litigation. They transferred me over to do False Claims Act, and I loved it so much. I said, this is it. This is where I'm going to stay forever. So in 2017, I left the government to represent private whistleblowers and to work with my colleagues at the Department of Justice on those cases. So the whole time that I was at DOJ, whistleblowers like you would file Qui Tam cases, and I would work closely with their private counsel to investigate the case and to litigate the case, or to settle the case or decline the case. And so working for years with the private counsel, I loved the private counsel bar. And I knew that one day I was going to leave DOJ and work with the private counsel bar. And I loved what I did at DOJ. So I was always telling myself, just after this next case, once this big case settles, then I'm going to go to the private bar. But in 2017, I just thought it felt like the right time for me to do that. It was after I had handled all the big lender initiative enforcement cases after the financial crisis, and we resolved all of those with the banks. And I thought, now is my opportunity. So that's what I do. I'm in Washington, D.C. at a firm. I also work hand in glove with my partner, Eva, who also worked in the same office at DOJ. Eva was the senior counsel for healthcare fraud. So we do everything together. Normally, she's right here with me. So picture Eva up here, Eva Sakara in spirit with me, because we work all of our cases together as in partnership. And so we represent, wonderful whistleblowers like you. And I will say that one thing that I have always thought about the clients that I represent is they are incredibly principled and have integrity, and frankly are far braver than me, because I don't know that I have it in me to be a whistleblower, which is why I'm grateful on the side of representing whistleblowers, because I think I think very few people can stand up. Call it what you want. You can call it, raising your hand. I think that's what you said, and that's really what it is. You are raising your hand and saying, wait a second, what is happening here? What I'm seeing, whatever the fraud, waste, or abuse isn't right, and I'm going to raise my hand. And I don't think most clients who come to me don't call themselves whistleblowers. Most people who come to me say, some other attorney sent me to you because I called that other attorney. And I said, am I at risk here? Like, I feel like I have legal liability because I know what is happening, and I'm really participating in it because I'm in the middle of it. And then typically, most of my clients come from other attorneys, of all kinds of attorneys who don't work in the whistleblower space, and they recognize, oh, wow, well, that sounds like fraud to me. I'm going to send you over to, Renee and Eva. So most whistleblowers are really just saying, wait a second, what is happening here isn't right. And so I find that incredibly impressive because I think a lot of us just do our job. We just go through the motions. Even if we love our job, we just go through the motions and we don't pause to think about, and what is what I'm being directed to do, what I should be doing. So thank you so much for your words. And I find them very inspiring.
I was going to say, Renee raised a really good point, and Rich and I, so we worked closely with Department of Justice, and believe it or not, we've had the same assistant U.S. attorney on this case since January of 2014.
Mm.
So we are also very unique in the sense that she's been on this case through even the settlement that happened in April 2022. But I first met her in Penn Quarter at DOJ in January 2014. And so she has been on this case, I guess, in I don't know what I would say her role is, but I think one of the other things is that interaction. And there hasn't been a day where I guess we had a pleading or anything that we did. I felt like I'm going to be in that courtroom. I'm going to sit right next to this U.S. attorney or assistant U.S. attorney. I'm going to put a face to this case because on the docket, it just says United States of America, relator Julie Reed versus. And I want you to know, everyone to know, even when I'm in the 10th Circuit, that I am a real person who is standing up, that there are real people who are involved in this, that this is impactful, not just to me, but I'm here because there's a reason, there's a cause. And I believe in this. So I want you to know that there isn't a single time that I won't put my face to it, especially in court and in front of Department of Justice or wherever is kind of involved throughout ours. I think I've sat in the galley many times, even though I wasn't allowed to speak or wasn't allowed to go up there. That wasn't kind of the proceeding. We were there, but there hasn't been a time that I haven't been there. And as a result of that, even our, the U.S. Attorney General, the Assistant U.S. Attorney General on our case knows exactly who I am, says hello every time we walk out, and, knows that I am the Qui Tam whistleblower that she, like you said, interacts with. And so that's been a pretty constant for us. I don't know if that's normal to have the same one for,
you're
8
lucky.
years or so.
People do leave, it is a revolving door a lot at different DOJ offices and U.S. Attorney's offices. So
I think that relationship has existed, even though their role is very different than my private counsel and I. But I think, I think it's important to, so you're a whistleblower, and I'm the only relator on my case. And so if I sit by the wayside, I think maybe I've done an injustice in the sense that I want every judge in the 10th or even my federal judge or the other side to know that I'm here and I'm going to fight for what's right. What that outcome is, I don't have control over, but I'm certainly going to be present and stand up for, what initially led me to raise my hand. So I think that's one of the things is if you have an opportunity to be present with the agencies and DOJ, who does make the decision that Renee just said, whether they're going to continue with that case, allow you to continue, whether they're going to intervene, all those things are so important. So that interaction, I think, is really important.
Yeah, I actually think that's a really good point because when I first left DOJ, folks would ask me in the first year or two, like, what surprised you the most, or what different view did this give you? And I always said, because it's maybe the main reaction I had, because I'm still in the same space enforcing the same law. But I really didn't give much attention to the whistleblower. To be honest, I was like, give me the case, focused on my defendant, focused on the evidence that you brought to me, focused on what evidence I could gather, focused on whether I could meet the elements of the False Claims Act, and really thinking, well, your lawyer's focused on you, and really had not appreciated. I fully admit, I think there are many of us in DOJ who become relators counsel, far more become big law defense counsel and represent the companies, but there are a decent and growing number of us who, when we leave government, we do go to this private plaintiff side, and we have this conversation among ourselves that we really gave short shrift to the whistleblower. We really weren't thinking about them. to some extent, you do have to focus on your facts in your case. And so it's a little bit necessary, but it gave me a totally different perspective and a renewed appreciation. And so I wish I could go back and change that a little bit about my practice. But here we are. So I do try to bring what you just said to the DOJ lawyer, because I know what they're thinking, because I was in the same position. So I do try to focus on what retaliation has occurred. And often DOJ lawyers are interested in that, because retaliation means that someone was trying to quiet you, which really suggests or is maybe more indicative of something isn't right, something's not right going on at the company as the whistleblower alleges. But I think that's important.
Well, the real risk for a lawyer, whether you're a lawyer for the whistleblower or a lawyer for the government, is that you can treat the case very clinically. And I think that's a mistake. If you don't consider the human element of the case, which is the whistleblower, so you're giving short shrift to the case overall, I think, but also you're denying that human element. You're not allowing the person to come through the process of doing the case. And I think when that doesn't happen, there's greater damage done to the whistleblower than was already occurring as a result of the experience that they've been having. So I think for us as practitioners, we have to keep that human element in mind, and we have to treat with compassion and with support, the folks that we're working with, because, this is one of the biggest things that some people will do in their lives, aside from your kids and your marriages or your relationships, this issue with your profession, with your livelihood, what you've chosen to do, what you put your creative energy and time into, when that is disrupted, it's so huge. And to treat it, sort of clinically and just look for, just the facts, just the law, trying to apply those things. Of course, you do have to do that, but you do have to envelope the human piece of it and make sure that it becomes part of the focus and part of your consideration. I agree with what Renee is saying about, sort of how you got piece, and you have to try to help the government lawyers and the judge understand those elements as well.
Yeah, I think it is a great idea to have the whistleblower show up to everything.
Yeah.
I feel that way now, representing clients. I do agree with that. We have litigation right now on a small business case, and the relator whistleblower is an association of small businesses suing, a gigantic company, and they could look like just an association competitor, but the president and the vice president of this little organization, that they are the organization, they come to every single hearing because they're like the face of the small business, conglomerate in this very specialized area. And I personally think it would make a difference to me as a DOJ lawyer if I was like each and every time seeing, okay, it's not an association suing this giant company that's getting all of their small business contracts. These are people here and they're small business owners. So I think I had not focused on that when I was the DOJ, but I think I agree with that.
And I think even visually, I can picture times when we're in the courtroom and Rich is speaking in front of judges, and I'm sitting on one side of the galley with my assistant U.S. Attorney General. Does she have to sit on my side? I don't know, but she sits on my side, and I look over at the other side, and that firm is large. And they have every law clerk and every intern and every junior, every attorney they ever could bring into this courtroom. And they stack that side to be extremely full. And they know who I am. And so their presence is known in that courtroom, but so is mine. And so I might be the only person, the only few of us sitting on the right side. And the left side is really stacked with people. I have no idea what they do, but it's meant to be a crowded room on one side. And it looks very off kilter. And I think to myself sometimes, if I wasn't sitting there and letting them point at me or no, that's her, she's the relator, and sit there, I wonder, what would it have changed things in a way where maybe the judges would, judges that were listening to Rich's, argument or whatever it was that we were doing, if I wasn't there and sitting by the assistant U.S. attorney, which represents the government, being present in this case as well, I wonder, would it change things? And so I think that as a whistleblower, as hard as that might be, and I think I got used to people pointing their fingers at me and kind of, doing that kind of, I would call it retaliatory in every way. It's meant to intimidate. But I think, part of me being there is showing that, I really believe in this, even though it's 9 years later. Like I still am going to be in that courtroom. And everyone's going to have to see me there regardless. And maybe it is, I didn't send out an invitation to every courtroom brief we had. So I would say, I didn't invite 50 of my closest friends to staff the courtroom. I didn't know it would quite be like that. So, but I think it's like just being strong in that conviction of how you got yourself there in the first place, and saying, I'm not going to back down. You can invite everyone that sits there. We're going to see it through, and I'm going to be the face regardless of what happens. I stand by what I did, and I'm not going to shy away from it.
Well, Julie, outnumbered but not outgunned.
Yes, outnumbered for sure, but not outgunned.
Well, and on that point, though, I think it really depends on the specific whistleblowers' circumstances and how they're feeling about what they're able to deal with as to whether or not to be present in these situations. That's part of our job, Renee and myself and others, is, look, we're going to take the heat for you if that's what we need to do. We're going to stand up for you if that's what we need to do. If you're there with us, it's terrific. But we do understand when people can't be there. There are circumstances under which, the emotional, and maybe just life itself, you have to work, you have to do other things. You just can't be there even if you wanted to be. And I just tell folks, look, that's fine. I'd love for you to be there. You can't be there. That's okay. That's why we're here. That's what we do. But yes, be present. If you're in a whistleblower case, be present as you can be. It does make a difference, both to your advocates and to the folks who are looking at the case, whether it's the judge or the other side. Jackie, I think you were going to say.
Well, so when you were talking, we think of that as being person-centered, trauma-informed. And I think there's been a couple of publications recently that I've seen about trauma-informed legal practices, and that is bringing an understanding of where and who the client is and their emotional state when you're bringing these cases. So like understanding whether or not the client can actually be in court, preparing them for that, but also understanding that there's going to be some triggering in being maybe asked some questions, seeing perpetrators, hearing and having to repeat over and over again. We talk about this with rape victims. Every time you ask somebody to repeat their story, there's a re-traumatizing in the retelling if it isn't done in a way that's meant to be healing. So I think this is, I think the conversation that we're having for what we do is really important to that understanding. Debbie, did you want to?
Yeah, I have a comment and then a question for Julie. I guess my first comment is in my case, and I was at the MSPB, so unlike yours that was in federal court, but my presence, I think, made the difference because so much of the judge's decision making was based on a credibility finding. That he had to weigh my credibility against the agency's credibility and my witness's credibility, which came forward, and then the other side's credibility. And so much of it was, his decision was a 68-page decision. I would say a good half of it was focused on the credibility findings, and as hard, as it was, I think that, I just got the support and the therapy and the tough love, and I just sucked it up. And there was a moment when the poker face judge, I think I saw a glimmer of shock or emotion, and I feel like that was the moment, and I was there for it, and maybe something I said or something enhanced my credibility at that moment. So, but again, mine, was MSPB. I'm not at federal court. God forbid, I have to end up there. But my question, Julian, you may not be able to answer this. I'm just curious, what were the alleged grounds for your termination?
Nothing you post. I would love to see it.
When Julie said a little earlier that she wasn't really sure, she's really not sure. She's not, she's not fudging it. We never saw a personnel file.
No, it's
So the letter that you sent, that they sent you telling
No.
you you're terminated?
no letter. There's no letter.
And I will tell folks that it is not unusual in the private sector in particular for you to be in totally good stead on Monday. And on Tuesdays, someone from HR and your boss walks into your office and says, "Hey, you're done." You can go home now, and we'll settle up with you, a little later. And I've had a number of clients in that situation who were totally awestruck, what happened? What just happened here? It's like something out of a dream or a movie or something
And I was very much the same. So on a Friday, I got my quarterly bonus. On a Tuesday, I handed over my badge and laptop in a parking lot of a grocery store.
And that's true, especially with government contractors. Do you think, Rich?
Yes.
Yeah,
Yes,
yes,
government
government contractors, they just, even when I was at DOJ, we had many government contractors working with us in our space. They were our travel agent. We had Sato Travel, they were government contractors. All our paralegal staff were government contractors, contract attorneys on document review. We might have 5 of them in our office one day, and then I don't know where they are. They're just gone, and probably some of them are terminated.
You have no protections.
Well, I would say, so one of the things that I've thought about a lot in this time, so the retaliation that I've experienced and it still continues today, it's not going to stop. Every opportunity that they have, they take, whether it be informal or formal. So my retaliation has been pretty vicious from the beginning, I would say, from that grocery store parking lot where we were certainly arguing over the security, the policy, the protocol. It was like nothing was followed. But I think in looking back now, one of the things that I've learned is that for a Qui Tam, well, at least in the 10th Circuit, which is where I am, is that for a Qui Tam whistleblower in the 10th, they believe that retaliation, and this is one of the things that other attorneys can speak on, but retaliation happens when you're employed there. It doesn't happen when you're gone. So you can only be retaliated against while you work there. So if you're a government contractor and you would like this person to be quiet, then you're going to terminate them and begin your retaliation because I'm not going to a merit board, or I don't have the same protections as being a GS or GG, or it's different. And so as a Qui Tam whistleblower, you can end my employment without, it's different. You can end my employment a little bit quicker and faster, but also in the 10th, the statute currently is that retaliation happens while you're employed there. My retaliation has absolutely happened from the day that I left, and it has not let up. And the reason why is because it's meant to silence me and to stop me from, it's to put me on a list and make sure that I never walk back in, and to stop me in this case, which, has gone on for many, many years, where I think, there is a recent case, and it's a Qui Tam whistleblower in the Sixth Circuit, where a judge has ruled that retaliation for that whistleblower happened after they worked there. And so I think that's one of the really big issues is, I would say it has been extremely difficult, the retaliation that has occurred. And I would be lying if I said that I didn't sit in that galley and just think, what is going to happen when I walk out into this parking lot, or, where's the next opportunity? I think I was very fearful because of so many of the threats, and Jackie spoke about this yesterday, and Rich knows me well because he's an attorney onto him over all these concerns. But I would say that I definitely would have, I've been diagnosed with complex PTSD, and it's a result of, enduring 9 years, 10 years of just some brutal retaliation, but also a loss in the belief of my agency's mission, the people that I considered family and friends that I worked with, that we dedicated our careers to. I started that job right a year before I graduated college. I was recruited, and I started in my early 20s. I never once believed anyone could do anything wrong at that agency. And when I found it, I remember making many excuses and going to everyone saying, did you forget this or that, or making excuses for, maybe we missed something and it's not what it looks like. And so I think I was in denial a lot, but in the 10 years that has gone by that I've been a whistleblower, I would say that that complex PTSD is kind of a loss of belief in the justice system, in the agency you work for, in the company, in the people, in the mission, all of it. And it's impactful in every way imaginable.
I have a question. Did the contractor use it to undermine your credibility?
You mean my
Diagnosis. Yes,
so they don't know that. So I probably had PTSD probably throughout this case. I think, can I say? So I have been talking to Rich as this case was coming to settlement. So obviously all my attorneys, settlement was not what I wanted. It's not what I believe is justice. It wasn't a settlement that I felt like I wanted to sign. It wasn't a settlement that I liked. I wanted to get in the elevator and leave and say to the government, have fun. You can sign, you can pay each other off and shake your hands and call it good. And this whistleblower won't be agreeing to it. And the government did not want to do that. And so the requirement was that all of us would sign. So I really struggled at the end of this case to settle. And I think it's because my expectations were not about money. My expectations were not about settling. I wanted reform. I wanted accountability, justice. It just didn't look like money to me. But I think at that time, in the course of this case coming to a close, is the time that I really had felt guilt and shame myself and maybe not being successful in this. And I expressed those concerns to my attorneys who I trusted. And thankfully, obviously, many have worked with other whistleblowers and said, hey, you might want to look at PTSD. And that's when I did reach out. So I would say that PTSD in my mind was something different. I had friends that had deployed in the military and things like that. I associated it very differently than being a whistleblower. And so it was a conversation with my attorneys and others that kind of led me down that road to go, wow. Is that really happening to me?
Rich, I think so what I think you're getting at over here is this idea that a diagnosis is then weaponized against the whistleblower. So, and I know we've had some of this conversation about what do you do when you're bringing these cases to court? Because are you looking for pain and suffering damages for the emotional distress? Or are you trying to hide any kind of, psychological care or treatment because it can damage the credibility of the case? So how do you mitigate that?
So there are a few factors to consider. And one of the special factors in Julie's case was that the nature of her job required her to have a security clearance at a high level. And those of you who are contractors or government employees know all about the security clearance, Damocles, a sword of Damocles that hangs over your heads, whenever you get out of line, so to speak. Because once they damage your security clearance, then basically you're not working. So when Julie speaks of retaliation going forward, she's really sort of subtly saying, yeah, they're messing with my security clearance.
9 years later.
And they have. So for those of you in that realm, that's an important factor to consider, and for a lawyer to consider as they're working with you. To answer Jackie's question, yes, it is a very strategic decision to make about what type of damages and what proof you want to offer to demonstrate those damages. So there are two categories, basically. There's one where you're asking for, emotional distress and extreme, impact on, yourself and your ability to function and all those sorts of things. And you're using, say, a therapist, a doctor, other people to attest to what you've experienced. If you do that and you go that route, you certainly have the ability to potentially have greater damages assessed in your case. But you also open yourself to discovery of all of your medical records and everything that you've ever done, medically or otherwise, and any doctor and every other person that you've ever talked to about, your condition, your issues, the medications you take, the whole 9 yards. And so strategically, one must make a very important decision. Are we going to pursue that level of damages, that kind of issue, or are we going to pull back a bit on that and go for what is referred to as garden variety pain and suffering, which is where the individual can attest themselves on the stand about the experience they've had. And that allows them in most jurisdictions to not have to give up their entire medical history in order to do that. But the damages assessed, if you will, are going to be smaller. With respect to the issue of weaponizing, these concerns, yes, where there's where there's potential fitness for duty issues, where there's security clearance issues, where there's other issues, if you are putting out there that I'm suffering from PTSD or some other significant mental or emotional, issue, that can very easily be weaponized against you. It will be weaponized against you either in terms of, well, this person can't, even if they prevail, they can't come back to work. They're not fit. They're not, they're not going to be able to function correctly. Or it will be used to show that you have weaknesses, you have problems, and this isn't job related. This is related to, a divorce or, other problems they have socially or, other issues. And so, yeah, it's a very, very, it's a very thoughtful dialogue that a lawyer has to have with the client about these types of issues and what strategy to employ that will work for them. Because if you're up for the scrutiny and if you're up for, using your medical history and so forth to justify, a potential award of higher damages, then that's great. But you have to truly know what you're getting into. And as lawyers, we have to inform clients of what they're getting into and not have them be surprised that, oh, suddenly I'm having to give up all my medical records. What? What's going on here?
So we're going to talk about it tomorrow, but we're coming up with a whistleblower protection with a whole certification where we're going to create dialogues and CUs on Jackie's Twitter to be able to have people be experts in this area to service whistleblowers Because I think part of the fear is going to people who don't really know and being called delusional or paranoid or getting a misdiagnosis, not understanding how whistleblowing can result in PTSD-like symptoms. And I think this is an area that we really need to figure that out, to have whistleblowers supported in a true clinical way. So people can understand what is going on.
So because of the harassment and the threats that she's getting, would a restraining order help in that effect? And would it affect, if she got one, would it affect her security clearance?
Well, restraining orders, you know, in employment context is pretty difficult, would be pretty unusual. I mean, they're more typical in sort of a domestic, you know, situation. I could certainly envision situations where potentially an employer or an employee of the employer are demonstrating physical, hostile, you know, characteristics toward a person, and that would be appropriate for a restraining order, or certainly a complaint to the employer. But in general, we don't see a restraining order of that nature in the employment context. And a lot of times the employee, like Julie was just describing, is already out the door. So if there are other forms of harassment going on once they're out the door, one of the questions is, does the law that the whistleblower is under, does it recognize post-employment protection for blocking someone's career, for taking other actions that would prevent them from moving forward in their careers? And that can be a state by state, federal circuit by federal circuit kind of analysis.
We have 3 questions. 4. 1, 2, 3, 4.
And we haven't let Dan introduce himself.
Well, you know, it's really interesting to me listening, because I realize I do have a different, first of all, I'm honored to be here. Of course, I don't know if Tom's here, but I followed GAP for many years. Who's here from Marion Scallett? Steve was one of my great 6th grade teachers. I go back. When you report to him, he'll say, Guttman said that, but you know what I mean. A very different perspective. I'm not really a lawyer, I'm a whistleblower. My mom was a great whistleblower, was part of the non-famous part of the greatest generation. She was a code breaker in World War II, then worked in inner city schools. Today we call them inner city schools, helping kids. And every year, I now look back, she'd be going to a different school. And now I realize it was because she was blowing the whistle all the time. So I've been a whistleblower. I wrote one of the first books on government contracting and doing that for Senate and all over. And so I whistleblower in the case that established that when SAIC lied to the Nuclear Regulatory Commission, you can't do that. And I also say that nobody should be a whistleblower lawyer unless they've had to sit and try to testify for DOJ.
Were you the whistleblower in SAIC?
Of course.
Oh, my goodness. I
And
didn't
to
realize.
sit in front of a jury is a humbling experience. And as you know, the jury found SAIC lied 77 times in the jury instructions. And my little brother, who I'm sitting in for, is my brother, the most creative and successful lawyer at the nexus of worker and whistleblower. And I spent most of the last 20 years in China teaching and developing whistleblower and public interest cases. And if I can, what I'd like to do is, these are what I learned from having to teach for a couple of decades in China, reflecting on our own system. I'll never understand China, but the virtue of being in another country is it makes you think about your own. First, I hadn't thought about, my brother and I became whistleblower lawyers because of our work for workers. And the 2 principles we learned. First, workers, no power, no money, but they see things that the goddamn CEO, broad division of justice, is clueless about. I was sitting in a restaurant with the then girlfriend, and she said, Dan, my brother complains he can't get clients. How do you get clients? My brother said, see this waitress, in those days it was women, she has no money, she has no power. She goes back into the kitchen, she sees the cockroaches, she sees the food's adulterated, she's not being paid overtime. The number of cases, the greatest single thing in American justice system is discovery. The number of things we discover, and I deposed any number, Ken Lay, you may remember, was that he was my first cross-examination. The number of things you get where the CEO said, holy shit, we're doing that. 1, discovery. 2, Another mentor said, you want to hide something from a lawyer, you want to keep a secret from a lawyer, you know where you put it? You put it in the law. Read the law. The number of cases we won because nobody read the goddamn law. This building owned by some goddamn big Washington realtor representing justice for janitors, they were trying to organize, but all the DC realtors, the owner of the, what's it called, the Washington Commanders, or with the baseball team, whatever the hell it is, tried to, they banned everybody, the janitors and their lawyers from entering the buildings, even for a hamburger. Went to the DC Superior Court, Human Rights Act. Rule 11 sanctions filed against us. They hadn't read the goddamn law. The DC Human Rights Act protects labor. So we got summary judgment again and again against Al Gore for poisoning workers in the nuclear weapons discovery, judgment that led to the 2000 nuclear worker comp law. 20 billion has gone out to 140,000 people. Read the law, talk to the people on the bottom. Three things I want to say from what I teach in China, 3 principles. 1, fact patterns. There is nothing new under the sun. When CFB or CBF or whoever, Sam Friedman, the crypto guy, everybody says another Ponzi scheme. We all know what a Ponzi scheme is. We have to look it up on Wikipedia, but we heard about it. My brother, where billions of dollars because the firms do the same thing again and again. In the US, it's called industry practice. In China, it's called hidden rules. So my brother's first set of cases, his was giving antipsychotic drugs to kids, off-label marketing. It's illegal. $3 billion cases. You think after the first one, the second and third companies would be smart enough not to do it. Kickbacks, Harvard professors, you name it. Again and again. Now, double and triple booking of surgeries. Harvard's hospital, Mass General. You go in for a surgery, you don't know. Your surgeon is in another room operating on someone else. Again and again. You have to know how to find the hidden first. The first rule is how do you find in the US, we call it industry practice. My brother's clue, associates to big corporate law firms are useless. The only effect of most whistleblower suits is so the corporation puts in a compliance program, ethics documents and training. So someone comes to my brother, so this is what's going on. The Wall Street lawyer, young kid goes to the CEO and says, anything going on? They say, no, we have compliance manuals. We have training. How can anything go wrong? Wrong question. The question is, do your competitors cheat? Yeah, of course. Do they ever win in competition with you? Yes. How did they do it? How do you ever win in competition with them? Yes, we do. How do you do it? Gee, I guess we follow the same cheating industry practices they do. You have to learn how. So I saw Booz Allen, now 300 million. It was when I started, I wrote our first book on government contracting. It's this seminal book, Shadow Government, 30, 40 years ago. It was obvious that much of the United States government is run by contractors against the White House inherently governmental policy, who are writing the policies, writing the rules. And it's obvious to anybody who reads Fortune or Forbes, these contractors are working for the industry that they're writing the rules for the government. So Booz Allen was a case. So Booz Allen was writing all the rules for DOE and EPA. How could it be that they're doing this when they're working for the oil industry? When I worked for the Senate as special counsel, I had access to the conflict of interest disclosure files. The government doesn't give them to you under Free Information Act Exemption 4. Turns out, all of a sudden, the clues, the fact patterns became obvious. First fact pattern, when Booz Allen bid for the contract, it said on a business proposal, hire us. We work for all the oil companies, so we know oil. But when it was asked to disclose its conflicts, it says, oh, our Kensington, Maryland office only works for the departments of in Washington. Well, obviously that was fraud. Second part of the fact pattern is you have to know how the government works. The people legally responsible for contracts, the CO, sit in the basement in the Forrestal building. They're wonderful people. They got hundreds of contracts. They're buying ketchup. They're buying Scotch tape. They don't know what the hell's going on. They rely on the so-called program officers. The program officers say, Booz Allen, Exxon, it's our buddies. Of course we want to hire them. Of course, right? Then The next level, nobody knows the degree of out and out fraud. So the Booz Allen case 40 years ago, we're on 60 Minutes. Booz Allen was hired to tell the Department of Energy how to plan for the next OPEC oil embargo. Department of Energy program officers say, well, they work for the oil industry, they know. What the Department of Energy didn't know, went over to Department of Transportation, there was a contract for bus service in Saudi Arabia. Booz Allen said, hire us, we do the planning for OPEC. So this was 60 Minutes that the program officers thought they were hiring a good old American. What's good for General Motors is good for, the United States, had no clue they were working for OPEC. Again and again. Next time is 2000. That was the SAIC case. Same goddamn thing. The NRC didn't realize you're the Philip Morris RICO case. Great Judge Kessler. I mean, a case before Judge Kessler found that SAIC was totally clueless and going to kill millions of people, injured because of a $250 million contract that Al Gore had been back of. The judge is finding SAIC, don't go near him. Go to NRC. SAIC was writing the rules for NRC on how to do the thing that Judge Kessler said was totally dangerous. I go as a public witness, I'm ranting and raving like now, and NRC says, what are you talking about? I said, SAIC, it's totally corrupt. They said, they didn't tell us that. And then when DOJ gets involved, I found out that SAIC was going to build $1 billion business based on the rules it was writing. Now we know McKinsey, opioids, right? Representing the Sacklers while it's working for FDA. Fact patterns, again and again, find the fact pattern. The key is, what is the clue? Once you've got the clue, GSK, my brother settled a couple of $2 billion case against the big pharmaceutical company. I'm in China. China settles for $500 million. We get whistleblowers from China. It's thrilling to me because all the discovery documents are in Chinese. So I learned corruption Chinese. I tell my brothers, it's nothing new, same thing they do in the US. I tell my Chinese friends, they say, everybody knows that. Same factor. So the second is impact. Colossal failure of the Department of Justice and the academics, the law professors, totally useless. The only thing law professors can write about is they can write about poor people, so they go do a survey of the legal aid, or they can write about cases. There is zero empirical research. The single greatest, for me, virtue of the American system is discovery. These cases today, millions of documents. Nobody knows about these documents, not the CEO, not regulatory agencies. You get them and you read them. They are a treasure trove of how to improve all of these things. We've got a totally flawed system. Your basic thing is DOJ can rack up. We settled for 50 million, penny on a, for nothing to these companies, and we agree to keep all the documents secret. Some of the stuff I found that would shock, most have shocked me, that's still secret because of these settlements. That's A. So it's secret, and all you get as a result is compliance manuals, compliance this. So more cover up. The only thing you get, that's the biggest impact. Third thing, and this is really an embarrassment to me as an American, having to teach the SEC, FCPA crap. I mean, that is, you want to know what an authoritarian country would do by whistleblower law, it's the SEC. Totally secret. They have these buddy systems that New Yorker and others have reported about it. A handful of lawyers who created the system make most of the money. All of their settlements are secret. There's nothing like the FCA. You can't force action by going to court, even if DOJ doesn't want to. Who the hell knows what the SEC has given money for? How can you ever have any impact improving the system? We don't know what the cases were about. And the thing that really galled me, finally with GSK, my brother and his colleagues settled for $2 billion. China, 500 million. SEC, GSK, 20 million. Who paid the SEC? Now, maybe nobody paid it, but competence questions. You talk about contractors. Foreign Corrupt Practices Act, much of the documentation is not in English. Who the hell in SEC reads Chinese? My former Chinese students are brilliant law students. They intern there. They read Chinese, but they don't know the pharmaceutical industry. Does anybody in the SEC have a clue as to what they're settling on? So again, finally, one Get a lawyer who reads the law. Get a lawyer who talks to people at the bottom, not the people at the top. Understand why it is that the corporate law firms probably don't understand what the hell they're trying to figure out the defense for. My mentor said, the great thing about a big law firm, I won't name Covington and Burling, is that they've got these associates who do all the legal research. Then you get the cases and they all support you. Learn how to make, the most out of the small amount of money you have. But the other thing is fact patterns. Our country has failed drastically of making use of what our systems discovery produces. You can't get law professors to do anything that requires lots of empirical work unless it's on the bottom. And three, God, somebody should bring the SEC to justice, but that's just my opinion.
Well, and we've had Tom Devine join us. He wasn't feeling well, so he's opted to come in virtually. So he's looming large behind you. Yeah. On audio, Paul?
Yep.
Tom, can we hear? You must.
Need to be louder.
Excuse my muted. He's not. Or talk. I asked it on you.
Oh, there we go.
My turn now, Jackie.
Yeah, wait, just a little.
Well, good morning, folks, and I'm so sorry that I can't be there with you. You're really the community that I've made my professional life around, and I so wanted to be participating for the whole event today. But I'm grateful to Paul and Jackie that they're allowing me to contribute this way. This conference is at a very significant moment for our movement, as we're in an unprecedented crisis for whistleblower rights. Part of it is the dissolution of the bipartisan consensus for whistleblower protection, at least on the surface. A bipartisan consensus for whistleblower rights that has existed since 1978. And that was shattered with the Ukraine impeachment hearings and Mr. Trump, after which whistleblowing became a partisan fight with Democrats supporting it and Republicans almost unanimously opposing the next generation of the Whistleblower Protection Act, which Republicans had always unanimously supported for 4 previous generations. It's an unprecedented challenge to our movement. The other reason that our movement is under attack is that there's been very hostile court interpretations of the laws that are already on the books. The ones that we have are being gutted, with access to court being removed, with burdens of proof being rewritten so that the rules are rigged and making it almost impossible for whistleblowers to prevail. So it's not a happy moment for our movement. But there are very significant opportunities on the horizon. And that's why this conference, I think, is particularly significant, because we're on the verge of busting out of this box that we've been captured in for the last few years. Part of it is legislation which is in Congress and is pending. There's about 85 bills for whistleblowing that are pending. Just the fact that politicians are introducing them, even if they're only for posturing or token, or to make a point or start a discussion, that shows that things are happening again, as opposed to being dormant. There's a few pieces of legislation that have a decent chance of making it through, overhauling the Veterans Administration's Office of Accountability and Whistleblower Protection, modernizing the rules for the intelligence community, which has passed the Senate now twice. But overall, there's one piece of legislation which is going to be the weather vane for whether or not we're rallying and coming back from the frustration of the last couple of years. And it's a piece of legislation that's intimately connected with the last speaker's insights. It's overhauling the whistleblower law for government contractors. This is a law which was passed in response to President Obama's stimulus spending. It was a major breakthrough for our movement, and it was because of $700 billion of new spending, and all the politicians felt that we better be taking care of that money. Well, now we've got over $4 trillion of new spending, and when Congress passed the first chunk of that for COVID relief, they didn't update or modernize the whistleblower protections. And predictably, what was the result? Well, Inspector General of the Department of Justice, Michael Horowitz, has estimated conservatively there was $100 billion of fraud just from the COVID spending alone. And now with trillions of dollars more spending, and as the last speaker pointed out, so much of it being directed by contractors, we're just have pretty much a standing invitation to get fleeced, for the taxpayers to get fleeced, and for us not to get the benefits of that spending, which is the reason that Congress passed it. That's created an opportunity to modernize the government contractor whistleblower laws. And it's a very serious effort that's been going on for several years. And it's one that would just totally overhaul the landscape for free speech rights of government contractors. And I believe set the precedent to restore the stronger rights for civil service whistleblowers. The legislation is in the Senate Homeland Security and Governmental Affairs Committee. It's got bipartisan co-sponsorship by Senator Peters, the chair of the committee, and Senator Braun of Indiana, a Republican member of the committee. Here's what the legislation would do. First of all, it would restore court access. There's a precedent in one judicial circuit that says if the inspector general doesn't help you, you can't go to court and have a jury trial like everywhere else in the country. You have to go to a company-sponsored and controlled arbitration, which means the judge is working for the defendant, and it's a complete kangaroo court. This would restore court rights and access without any question. Secondly, it would protect people for refusing to violate the law, just like is available for civil service employees. Third of all, it would expand the scope of whistleblower protection from just challenging fraud, waste, and abuse in domestic contracts to international contracts as well. So that all government spending would be covered by the government contractor law. It would protect corporations as well as employees. It would give the inspector general the authority to discipline those who engaged in retaliation against whistleblowers. And I've saved kind of the most significant two provisions for last. One is it would, for the first time in a major scope in the United States, create a whistleblower defense against retaliatory litigation, SLAPP suits, criminal prosecutions of people for blowing the whistle. And ironically, in the United States, you can file a SLAPP suit that'll bankrupt someone or send them to jail for activity that you can't fire them for in the workplace. And as our workplace rights have expanded, employers have shifted to that tactic where the whistleblowers are defenseless. About 2/3 of the world's nations, whistleblower laws aren't just for workplace harassment. They're for any retaliation, including SLAPP suits and criminal prosecutions that you can defend yourself with. Nearly all of them over the last 10 years. The United States is the dinosaurs in terms of excluding one of the primary areas of attack on whistleblowers. This legislation would create a whistleblower defense against those litigation. It would help people like the Urids who are facing SLAPP suits for challenging medical misconduct. The seventh thing, which is not on the bill, but is the subject of a Republican amendment from Senator Rand Paul, is to close the loophole that excludes intelligence community contractors from the government contractor whistleblower law. This would be giving whistleblower rights to people like Mr. Snowden when he was challenging domestic surveillance. Right now, there's a blank check loophole for the entire intelligence community for any government contract spending. If you're a whistleblower, you don't have any rights to challenge it. This would change that. Folks, this is something that's really worth our focusing on and aggressively giving our solidarity to. There's going to be a Senate vote on the Homeland Security Committee in late September or the first week in October. There was going to be a vote for this in July, and there was strong bipartisan support for the reform, but the contractor community just went rabid. Did a lobbying blitz in July, and almost all of the Republicans who said they were going to vote for the bill switched to undecided. And so the chair of the committee said, well, we better do some more grassroots support for these reforms. And now is our moment. GAP and the Make It Safe Coalition just yesterday sent out action alerts and petitions to all the people in our community. In the Make It Safe Coalition, Whistleblowers of America got one to distribute. Public Citizen is doing. We have bipartisan support from the conservative as well as the liberal NGOs that support whistleblower rights. We've got a month to prove to Congress that they have to protect the $4 trillion plus of new spending that they've enacted. And if our voice is effective and it's heard, those Republicans will get back on the right side of accountability. If we're passive, the contractor lobbyists won't be. And we're liable to miss this opportunity and still be stuck in the purgatory of partisan conflict for whistleblower rights. That's not the only thing which is on the horizon and important for our movement. Last Congress, the House passed a badly needed overhaul of the Whistleblower Protection Act, which hadn't been revised or updated for over a decade and has become increasingly obsolete. The legislation to modernize the Whistleblower Protection Act would give federal employees jury trials. They're the only significant portion of the U.S. labor force where whistleblowers don't have access to court. They have to go before a bureaucratic board, which is a national disgrace. It would give them protection against retaliatory investigations when they're opened. The first move against whistleblowers always is a witch hunt. It would give them a realistic chance to get temporary relief when when cases routinely go for 3 to 5 years. We have one client who's been twisting in the wind for 15 years. Because of recent developments involving the Biden administration, we've got a real opportunity to close the loophole that leaves whistleblowers defenseless against security clearance retaliation. And our coalition is working with Republican members in the House for legislation that would close the security clearance loophole and get jury trial access for government whistleblowers. In a sense, we can think that while support for whistleblowing hasn't been so bipartisan, retaliation still is bipartisan. And the Biden administration has been retaliating against the people who blow the whistle against them. And that may be reviving our beachhead for bipartisan support for freedom of speech. Folks, that's sort of the diagnosis right now. This next month is going to be very significant for our movement. Be on the lookout for the organizing and the outreach and make your voice heard. And if you do, I think we're going to have our breakthrough.
So thank you, Tom. I think we're gonna go back. We have some questions in the audience. I know some people were eager for you to be here to ask some questions. I know we were, yeah, here we go.
Over there in the corner. There is someone over there in the.
Yes, good morning, all. My question is that you had explained about the security the issue. However, when writing up the agreement or whatever the settlement was, could some of those things have been written in there and that they would cease from no more once it was over with? Because my question is this becoming a part of being defamation or slander? And I know they can possibly, she applies for another job, they can do a background check and they may see her name. However, based upon the agreement, because she can't discuss certain parts, why can't that be the same for who she went against? And that's my question.
So it's a great question. There's a complicated answer in Julie's case. In Julie's case, the case that settled was the False Claims Act case, the Qui Tam. She had 2 attempts at opposing the retaliation through legal channels. Both attempts lost. One she described in the 10th Circuit. 10th Circuit is a circuit where if you are a compliance official, somehow you have to identify yourself very specifically when you're doing whistleblowing as opposed to your compliance work, which sounds completely ridiculous and isn't in the law, but it is the way the Court of Appeals from the 10th Circuit and some other circuits have interpreted the scope of protection for folks like Julie. Julie was denied protection under the False Claims Act whistleblower protection provision for that reason. With respect to government contractor whistleblower protection, Julie had a claim there as well. But unfortunately, it was back in the day when there was a pilot program for federal contractor employees to be protected. And the pilot program required that the agencies informed their contractors that they were going to apply a new standard for whistleblower protection as part of the pilot program. And that would then trigger the responsibility for those contractors to behave accordingly and to have to be compliant with that provision. Well, what do you know? The Office of Personnel Management, who managed the contract for Julie's contractor, did not do what it was supposed to do under the pilot program. And as a result, Julie was not protected by the law that was established in the pilot program phase. So she had 2 shots at attacking the retaliation she suffered. And in both cases, she was not able to get the results that she needed. But to answer your question about, can these things be built into settlements? Yes, if we had the opportunity to settle or to litigate the retaliation piece, we would certainly do our best to incorporate as many protections going forward as possible. Now, what you all need to understand, or whistleblowers need to understand, is the more you want in terms of protection and moving forward, the more restriction the other side is going to want with respect to how you can talk about, if at all, the experience that you just had. So on the one hand, Julie's defeat around the retaliation pieces was disastrous for the reasons that you're pointing out. There's no protection going forward. On the other hand, she's free to speak. So, they're kind of so there are these issues, but we would in a retaliation context, we would typically seek as much protection going forward as possible. And part of the negotiation often is, look, the company wants to go forward, our client wants to go forward, let's create a path forward, not looking back, so that everybody can go their separate ways. And that can often be an effective tool for negotiating something along the lines of what you're suggesting.
So settlement and settlement options is something I think people are very often confused about. Because I will hear from people, oh, they've been on for 5 years, they want to settle, what do I ask? So maybe Tom, I know you deal with this, Renee. Can you give us a few minutes on settlement options and what those might look like, or what should people be thinking about for settlement?
I mean, I think I raised this in our pre-meeting discussion. About half of my clients that I represent in whistleblower reward program have not been retaliated against, do not have retaliation claims, are continuing to work at the company in which they have filed secret under seal lawsuit, and there's an investigation going on for years sometimes. I have one current client who has whistleblown at the age of 22 as an entry-level employee and has been promoted like 5 times during the course of this very large investigation going on in his company. And so he may actually want to stay at the company when the case is unsealed and the case will be settled. And as I was also mentioning, about a year and a half ago, less than 2 years ago, I had another client who is a pharmacist and blew the whistle on his company, and he loves his job. He loves the people he works with. He loves what he does. It's a great job. He did not want to leave the job. So after the case was unsealed and settled, and he was revealed as the whistleblower who filed the Qui Tam, he said, I want to keep working here until I retire. I have no intention of leaving. And so he worked that out with the company counsel and said he wants to stay and he doesn't want to go anywhere. And he's been there for a year and a half, and they still, still text me from time to time. And no one has said a word to him. No one in management. He hasn't been demoted. He's still allowed to telework as pharmacist, which is what he had hoped to do. And in some ways, he feels as though he is getting a better teleworking deal because they might be a little bit afraid to take any kind of negative action against him. And so if he, if he's required to telework under a different agreement than he wants, this is his feeling, he doesn't know, but he's got a very good telework deal, better than some other employees in his situation. So my point is, not all of these cases are retaliation cases, and to have a whistleblower reward case, you do not need to raise your hand inside your company. You can see what's happening. You can identify it as possible, as you said, fraud, waste, or abuse. You can go to an attorney. You can file an under seal Qui Tam, and you don't necessarily have to complain internally or raise the issue as a problem. And some of our probably best cases, coincidentally, it's really just coincidence, but some of our best cases are whistleblowers who never said a word about the fraud. They were in the middle of it. They have a lot of text messages and emails, and they had a lot of evidence. And they may have asked questions, but they didn't say, hey, this is fraud, and they didn't raise their hand internally. They just decided, I'm going to an attorney, because again, most of those folks are coming to me not because they called a Qui Tam lawyer. Almost nobody does that. They called some friend who's a lawyer, or father's an attorney, or father is a friend who's an attorney, and they say, holy cow, like something bad is happening at my company, and like I'm in the middle of it. I'm on emails about it, and I think it's fraud. And then they say, oh, it's a Qui Tam, because a lot of lawyers do know what a Qui Tam is, and their ears perk up and they think, oh, this could be fraud against the government because it's a government contract or a government contractor, or they're in the health, they work in the healthcare industry, so they end up at my space. And frankly, if someone hasn't raised their hand in the company and they've contacted me and they provide me documentary evidence and I think it's fraud, I say, don't talk to anyone. I don't tell them to go run to compliance and HR and start raising their hand. I say, give me time to evaluate what you have told me and shown me. Give me time. And then I can tell you what your options are. And then we can talk about what you want to do. And do you want to file a Qui Tam, or do you want to go to compliance? Then you have a lot of different options, but not everyone who's in a whistleblower reward case, whether it's SEC whistleblower reward program or the False Claims Act, or there's probably 6 or 7 whistleblower reward cases where, you're seeking a financial reward, and you're going to blow the whistle. And so it's really the folks who have already been fired or have already been retaliated against who are then seeking an employment counsel. And, you know, they may land on somebody like Rich's desk who does both employment law, retaliation, and Qui Tam work, or they'll be sent to a firm. You know, if an employment firm isn't doing that kind of work, then they'll send them over to me and say, I'm looking at their retaliation claim. Can you evaluate this for False Claims Act? And then we can work together and figure out what the options are for the employee. But point being, your settlement options are, you know, it depends on your unique circumstances. And you can remain at your company. And I do have some undersell cases where the employees have told me, my clients have told me, I might want to stay at my company. Can I do that? Sure, we can talk about it. Your company might just continue to keep you in place, or they may offer you a big package because they actually do want to get rid of you, and then you'll have to think about that. And we've worked out arrangements in both sort of circumstances.
So Jackie, to answer the question about, you know, what do you ask for in settlement? I think Renee is touching on it. It really depends on what kind of case you have, right?
Yeah.
If you have a False Claims Act case, that's just about the false claim and the fraud, then that's really between you and your lawyers and the government, right? If there's a retaliation component, then that's really yours alone. And you make the judgment with your lawyer about how to approach settlement, whether you stay, whether you go. I will say my experience is that most companies and even government agencies don't want whistleblowers around anymore. And even if you have the right to stay, if there's a negotiation, their negotiation focus is that you're going. And so you have to be prepared for that as part of, you know, whatever you're going to end up with respect to a settlement. So, and in the case of other reward programs, so the False Claims Act reward program is interesting because it's a reward program that's kind of driven by the whistleblowers. The other reward programs are the SEC, the CFTC, Department of Treasury's Anti-Money Laundering Bank Secrecy Act, the Department of Transportation with regard to motor vehicle defects and those sorts of things. All those programs are black boxes, and you end up with possibly engaging with the agents who are seeking enforcement action, but you may not learn anything about the specifics of what they're doing or not doing until they decide. They tell you either, never mind, we're not going to bring an enforcement action, or they bring an enforcement action and suddenly you're realizing that you might be eligible for an award. It is very, very black box, and it's very difficult to navigate that. And in those situations where you're in those types of reward programs, there is no settlement because, as Renee said, there's not, you can be totally secret. There's no issue with respect to your role in the company versus what you've disclosed to the SEC, CFTC, Treasury, or others. And so you are not in a settlement position. You are mostly trying to do whatever you can to help the government enforcement team bring an enforcement action that will be usually in excess of $1 million to qualify you for an award of between 15 and 30%. So settlement or the outcome of your situation depends very, very significantly on what form you're in and what kind of case.
I thought I wasn't gonna have anything to say, but I do, and that is, yes, every life counts. We're talking about the public interest here. We're talking about our country. Where is the public interest in a secret settlement, maybe gives the whistleblower God knows what? So again and again, okay, one of the core problems we find, we go, is who's the biggest defender of the defendant? It's the agency that's been screwed. You just can't get the agency, you can't get DHHS to testify on Medicare fraud because they love whoever the insurance company is. So one, will the settlement change an agency behavior to anybody? So for example, in the Mass General double, triple booking, Lisa Kleiman, the whistleblower, was an anesthesiologist. She'd been fighting for many years. The case went on for decades, but God damn it, she wanted Mass General as maybe the leading hospital, the Harvard Hospital, to change its informed consent forms to tell patients, hey, you may be lying under anesthesia for a couple of hours, your doctor won't be there. Is that okay? So we're talking about not simply, the individual rights, but there's zero. I know Steve Scallett and Cyrus, for many years ago, you had the common fund business with all your cases, but that's gone. Where is the interest in a public interest component of a settlement. Of course, when you've got the SEC, there's nothing because nobody knows what's going on. But when you've got DOJ, you can argue for it.
Yeah.
You know, where is that? What is it? You don't read the law journal articles about this because the law professors are writing about cases. Most cases get settled, there's no decision to write about.
Well, and I think a time when the government comes to settlement, and I think you talked about like injunctive relief, that people can ask for that they can ask for the policy or something to be fixed as part of their settlement.
You mean within government or within the private company?
Well, with the government,
You can ask for anything.
well as
You can ask for anything, but if you insist on it.
at the federal. And then we've also had a question about retaliatory investigations that was for you.
Thank you. There was another question about the timing of the Senate committee vote for the government contractor bill. That'll be the last Wednesday in September or the first Wednesday in October. The Republican senators on the committee to target are Senator Paul of Kentucky, Senator Hawley of Missouri, Senator Johnson of Wisconsin, Senator Scott of Florida, Senator Langford of Oklahoma, and Senator Romney of Utah. Senator Scott is particularly interesting target because he owned Columbia Healthcare, which was the defendant in the largest False Claims Act successful litigation in history, $5 billion in fraud. So you can understand why he's very hesitant for accountability of government contractors. With respect to the question on retaliatory investigations, the question was, well, you know, what do these look like? And I would say I kind of break them down into three general categories. One is just looking for dirt without any particular catalyst to it, just starting to dig. For example, one of our clients who is a criminal investigator for the Inspector General challenging sexual harassment in federally funded programs. The IG interviewed 300 people going back 30 years over his life before they found some dirt on him that they used to criminally prosecute him then. Just starting to dig. The second thing is to basically turn the tables on the whistleblower. I have several clients currently who had made whistleblowing disclosures to internal affairs units. This is particularly popular with law enforcement whistleblowers. They make allegations to the Internal Affairs Department and find themselves under investigation rather than the investigation or than the misconduct which they alleged. It becomes very dangerous even to put issues on the table because the table will be turned on you. The third is kind of a more sophisticated form of mobbing, recruiting employees to file allegations against the whistleblowers. So it's not coming directly from management, it's coming from colleagues, but it was coming from colleagues after getting a carrot from management if they would do the dirty work. Those are the three most common scenarios that I've come across.
Yeah, it's a point. A comment, you know, we are backward. China, Article 41 of the Constitution has a whistleblower protection provision. So this is not something, you know, but then the other side of it, it's a longer conversation, and it's a different thing. You know, I was special counsel in investigations of contracting. I've testified many times on this before the Senate and the House. It isn't obvious that law will be able to make any difference in the contract system. For most fundamentally, because the cow was out of the barn 50 years ago, after World War II, the military-industrial complex, we turned over the basic governmental functions, most famously nuclear weapons, to private contractors. The fiction under White House protocol is that the government officials are running the government. The reality ain't so. And so you've got dual sets of rules. The whole system is premised that civil servants are under all kinds of rules. You can't strike, FOIA, ethics, they don't apply to contractors. the notion that you can fix it by any kind of government, by any kind of law, it isn't any longer obvious. Question for all of those who are voting in the 2024 election when we'll talk about President Trump. When Vivek says he's going to eliminate the civil service, have they thought about what he's going to do with millions of contractors that are still left there?
And then we have more questions. Yes, Ted.
Yes, so I sit here, listen to all this. This is really disturbing because this is not a government of the people, by the people, for the people, it's of the corporations, by the corporations, for the corporations. They've got deep pockets and lawyers to boot. A lot of lawyers but like to make a lot of money working for these corporations. And so I listened to Julie's story and some other similar stories. You can't get personnel records. Just like there's laws that are favoring them that they set up totally against the whistleblowers who have no rights. How is it you can't get personnel records? Because you need to know why it is they're firing. You have a right to know that, but there's laws that are set up that prevent that from happening. And that's got to change. And unless that changes, none of this is going to matter. You know, it's so what's being done, you know, at a grassroots level, it's going to turn the tables on these corporations because the politicians are lining their pockets, you know, with lobbyists and you know, special interest groups in their favor and big pharma, and I can go on and on about all that. So how do we overcome that?
Well, that's a tall order. I mean, there are different components to what you said. One are personnel laws, you know, and that's something that, you know, maybe Rich has some thoughts if he were running the world, sort of responses to that. But for me, you know, for me, the answer to part of what you're asking is the False Claims Act. I'm a big believer in the False Claims Act, and it has limitless opportunities to pursue all government contractors, everyone in the healthcare industry, anyone who does business directly or indirectly with the government. With the private whistleblower bar becoming stronger, which it is, defense counsel say this, big industry says it, DOJ says it, it's a fact. Private plaintiffs bar has become more sophisticated, more well-financed and better over time. And so last year, as Rich knows, and you probably both know, for the first time in False Claims Act history, the whistleblowers private bar recovered more money for the federal government against healthcare industry, government contractors, and anyone who does business directly or indirectly with the government on behalf of the federal fisc. So the False Claims Act is a different law than all these other laws, which I don't practice, which this is what everybody else is here to talk about. Under the False Claims Act, that is a statute where you are pursuing a case on behalf of a defrauded government program, no matter what it is. So every single healthcare industry participant participates directly or indirectly in the Medicare program. It's the biggest insurance program in the US. And there's not a single healthcare entity that isn't catering one way or another, whether it's drug manufacturers, laboratories, doctors' offices, hospital systems, to the Medicare population, as well as, of course, to private insurers. But what the False Claims Act allows is for a whistleblower, you know, ideally, but as I mentioned earlier, I represent an association that's not an insider to the big company. So anybody can really be a whistleblower, but insiders like you are going to actually have the information because they work inside the private company. So they're going to have information the government does not have about fraud that's happening on the government program. And it allows the whistleblower and their attorney to file an under seal private secret lawsuit and allow the DOJ time to investigate. Now, depending on the audience I was speaking to, whether it were the defense industry or I was speaking to government lawyers or private plaintiffs, I would have a totally different message. If I was speaking to the defense industry, I would say this is a big, bad, powerful tool, and we're coming to get you, and we're coming, you know, we're coming harder than we ever have. Here, of course, I will say, and this is what I'll be saying in Taxpayers Against Fraud at the next conference, is that we have to continue to push DOJ for the reason that you're saying, Dan. We have to continue to push DOJ to use our resources to allow us more deeply inside their investigations, because we have the sophistication, the knowledge, we have resources, Now, we're not big law, right? None of us firms here, right? You know, hello, how are you? And welcome. I see you slip in back there. We are not big law. We don't have tons and tons of associates, but we do have resources. And folks who practice in our space are really deeply entrenched in False Claims Act jurisprudence, as like Ruben, who I worked with for years when I was in the government. And so that's my message to those of us who are on the government side, on the whistleblower side, on the private plaintiff's bar. We have the ability here. We just have to work better together with DOJ and the private bar so that we can file more False Claims Act cases and we can increase the percentages of cases that actually get recoveries and in which the government actually intervenes and takes over. And then, of course, at the end of the day, in which the whistleblower receives a reward. Now, that's different completely than government employee retaliation whistleblower programs and other types of whistleblower programs that you might pursue, like at OSHA, and I know there's like 100 of them, and I don't practice in those areas, where if you're working at a government contractor, you have these other avenues. But the False Claims Act is the government's tool, right? And it's always the government's claim. It's never the whistleblower's claim. Instead, the whistleblower, at the end of the day, gets a statutory right to a share of whatever the government recovers. I'm sorry.
No,
I'm gonna say something.
I'm a lawyer too, so I fully support filing more False Claims Act cases. But I work with Richard, and Julie was also my client, and I know Renee and Ruben way back in Tom.
And the former executive director, right, of Taxpayers Against Fraud?
Yeah.
Yes.
And I had a conflict this morning, so I was listening in and just.
But so that's my answer, right? I don't know if you agree with me, Cleveland, but
Yeah, I do.
the tools are there.
I think for
We just need to be more
a
resourced.
different reason also, when I first came into town, the False Claims Act had been under consideration for some upheaval, and courts were getting things wrong, and Congress needed to know that. And so I was compiling lots of data to show Congress, these are issues that don't comport with what the law says. Courts are interpreting the law incorrectly. So it's unfortunate that sometimes lawsuits show the deficiencies in the law that Congress needs to fix. And so the statute was overhauled in 2009, again, some more amendments in 2010. And, some of the retaliation issues that Julie mentioned, are being considered for amendments because unfortunately, bad case law is made, and we point out this is not what Congress intended. You guys need to fix this, and Congress has been at the forefront of a lot of road efforts. So I think there is value in continuing to pursue the cases because even when the courts get it wrong, it gives us opportunity for the change that gentleman.
Senator Grassley has been at the forefront of
Absolutely.
when the courts get it wrong, he amends the False Claims Act. But the problem that we have is Senator Grassley is very old, still got all his faculties, but he's not going to be there forever. And we need a replacement, as we all talk about in town, for Senator Grassley being as passionate about the False Claims Act, someone else being in Congress, some senator being as passionate about.
But I think your question was broader, right? So
Yes, and right, and with what you were just saying is another good point that piggybacks off what I was saying, is the laws have to change. It's great that these errors are identified and corrected, but in general, it seems like some of these laws have got to change to favor the corporations that's stacked against the whistleblowers.
So the answer, I think, is you have to support organizations like Whistleblowers of America, Government Accountability Project on Government Oversight, the folks that are on the front lines of trying to change the laws and trying to get access to our representatives, our senators, et cetera, and even go down at times to the state levels. That's where the change has to occur. We need a federal law because the federal law covers the entire United States, right? Can't do this piecemeal because you don't get protection that way. It's great if you're in California, but if you're in Indiana, not so good, right? So nothing against Indiana. But I think the goal is, the aspiration is, and what Tom has dedicated much of his career to, is creating baselines at the federal law level that provide the kinds of protections and the kind of tools that people can use to protect themselves or defend themselves when they find themselves in situations as whistleblowers. So that would be my answer to your question.
Let me take the contrary position and supporting and reinforcing what you both said. My first book, the book was for Ralph Nader. So I started off, I mean, I'm not, corporations. However, from the perspective of someone who's done this in China, discovery is extraordinary. What Tom will point out, you'll point out that the Supreme Court has eroded Iqbal and Twombly. When I was in law school with the J. Willie Moore, you could spit on a piece of paper, file a complaint, and you're entitled to start a case and then get information. Bill Clinton, follow whatever, could go to court against Bill Clinton. Discovery is immensely powerful. The Supreme Court is limited now. That's the question. But what you can find, this goes to all of your questions about personnel file, for example, the CEO, Morgan Stanley doesn't care about any of our personnel files. He cares about CYA in relation to the big picture. Now, you tell them you're going to have a lot of problems with a lot of people, maybe the Chinese government, maybe whatever. He said, oh, what do you want? We'll give you anything. So the point of it to me is we still have an extraordinary system to the extent you can get into court with legitimate, meritorious, not an harassment suit, and get into discovery. You've got a pebble to stand on. The CEO, want your person, whatever you want, we'll give it to you. Just don't throw me into the briar patch.
I've had experiences that are completely different. And the Qui Tam thing is a little different story. You're kind of the whistleblower is working as an ally of the government to recover money for the government. So that we put that aside. I'm a physician. I've actually spoken with you, Richard. I'm John Breda. 2019, I think we spoke. And I am the victim of sham peer review, false reports to the National Practitioner Data Bank, whistleblower big time in 2018 when I learned that 1,000 physicians, innocent physicians, have been reported to the NPDB by the government. That was told to me by Congresswoman Custer's office, one of the staffers came over. And I saw this being a bigger issue. And there has been no accountability whatsoever. I have a whistleblower retaliation claim that I just appealed to the circuit court, federal district, because the ALJ, despite my compliance with his orders, gave me no discovery rights whatsoever. And I asked for a dismissal without prejudice. He wrote a final order, and I used that final order to appeal to the circuit court.
What forum were you in? Which ALJ? What agency?
I'm the ALJ is in New Jersey.
I mean, what agency?
VA and the NPDB. The VA has lied, covered up, ignored laws. 9 years of hell. To the point that I was put under such stress because of this, because a report to the data bank destroys your ability to use your medical license freely. And you have to deal with the shit that is completely fabricated out of a sham peer review situation, conclusory decisions that made behind closed doors. I mean, there's no due process, there's no constitutional rights. It's absolutely absurd. And that needs to change. There's an affiliate person I've come to know who is the physician representative for the American government, the AGFE, right, the union, who represents 80% of the physicians in America that work with the VA. And he said to me correctly that sham peer review and improper reporting to the NPDB threatens every single credentialed licensed physician in America, period, hands down. And I agree with it. If it can happen.
That's what Tom was just talking about, retaliatory investigations,
Right,
talking about
right.
peer review,
And
the same kind of thing.
this takes me back to a conversation I had with the GAO. I was in the lobby of the Senate building, 2018. And the person I was talking to was in the fraud department. And she said, what you're describing is business as usual in Washington. And how much of this corruption, trying to live above the law. I mean, I filed 2 Privacy Act letters. I received no response from the MPDB. Yesterday, I received a response from Lowenstein, the head of the MPDB, basically saying, we responded to you in your dispute process, yada, 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 never answered my question. I received a response from the VA, from the director of the medical center in Providence, basically relying on a letter from the Visit One director, which was a pack of lies. And he said, you know, that we did everything right and you've been given due process. And then I received another letter a couple of days ago from Washington, from their privacy officer, saying, I know you've been responded to, but we're going to review this and get back to you in 60 days. Well, guys, you haven't met the statute. You know, you're already 30, 40 days beyond the time limit, and you're going to send me another package again. And it's like it goes on and on.
I don't think there's any disagreement. I think this may be actually a useful conversation. I assume everything you're saying is correct.
It is.
But we have experiences like that. Why we're talking about the False Claims Act, it's a fundamentally different statute. First of all, as Renee say, we don't agree with the government. Half the time we're fighting with DOJ. They want to settle, they don't want to do it. But you have the right as a citizen, until the court throws you out, to go ahead and get the discovery if you're doing it. So the question I would ask you, and this is not giving legal advice because you practice as a lawyer, is can you transform what I would call your fact pattern into something that will be capable of making a claim under the False Claims Act where you would be entitled to get the discovery?
But I'm not making you, there's no claim here.
No, but that's the question. That's why you want to talk to Renee or someone. How do I So we settled the case for 280 million. Peer review scandals was a core part of that. 280 million bucks. The Justice Department. This was the largest case which the Justice Department went to. Didn't intervene.
Maybe
the case.
Maybe there's a twist here that I don't.
But I mean, I don't practice law, but these people do. Speak to lawyers.
Qui Tam is a third party, involves a third party scamming the government and a whistleblower bringing that to someone's attention.
Right.
My situation is a direct attack against me and other physicians through sham peer review, making.
But here's the point Renee was making. If anything that you're dealing with involves taking money from the government, which is our medical system, then you can translate that.
Yeah, but my situation is not that.
No. And it's the core thing, and thank God Justice Scalia doesn't believe in originalism. He is the reason we're here on the Qui Tam, because he found it constitutional, in part, to bring a suit in the United States, you've got to show generally that you're personally injured. But under the fiction created by Justice Scalia, the fact that you might get a bounty is your personal injury. So it doesn't matter if it's not your journal article, whatever. It's can you connect what's happening to some company getting Medicare approval because of these period, for example, it gets the, the compendia, for example, right? The compendia? No, this is part of our accounting case. So these, even if you don't get Medicare approval, you can still get reimbursement under the protocol if you're in something called the compendia, which is created by all of these phony baloney corporations. How do you get into the compendia? You hire a company to write articles and fake all this stuff and blah, blah, blah. So what you want to do is talk to someone, talk to people who know the industry. How do you translate your fact pattern? You got a fact pattern, or many fact patterns, which are probably very basic to the way our system works. How do you translate it into a legal claim under, for example, the False Claims Act, where you don't have to show personal injury. You just got to connect it because somehow the government's paying money.
I agree that that's a good way to think about a whistleblower fact pattern. Sometimes when the situation feels very personal, sometimes you are still blowing the whistle or recognizing an issue that goes beyond the person.
Well, that's correct in terms of my whistleblowing when I learned of the 1,000 physicians, because they're destroying people's lives, careers, yada, yada, yada. There's all, I mean, the government, you know, I'm into my case now for $400,000. Okay. I assume the government has spent many times that, all right. Of course, it's not money spent, but it's salaries, it's time, it's fraud, waste, and abuse. So yes, the government is involved paying something, and at some point, who is driving this? It seems to be people who are trying to cover their ass because they've done something wrong. They don't want to admit it. And they're just going to continue to drive this. And that drives the waste, fraud, and abuse, and it just spins down. So what I've done is I filed pro se a 50-page lawsuit in federal court, which is now being amended, which I'd like to talk to you about.
What's the legal statute, the legal basis for the claim?
It's constitutional rights, lack of due process, stigma plus, Bivens claims, and intercorporate or interagency conspiracy. Because I've got lies, cover-ups by about 8 different people.
I don't think you're not using the False Claims Act.
Yeah, no, I'm not using the False Claims Act.
Well, so just to close on this for just a second, because I think you're raising a very valuable point that goes beyond your situation. Whistleblowers who have licenses, medical license, professional engineer, whatever else.
That's property.
Right. You have a property interest in that flag. It is also a point of vulnerability. They go after your license when you're a whistleblower. They try to cut your legs out from under you in terms of your ability to work.
And in my situation, they tried to do that with the state boards. The state board reviewed all this and wrote them back and said, there's no unprofessional conduct here. But they have still retained me in the database. And there's a case in Vermont, which is astounding. It's an orthopedic surgeon who was sabotaged by the hospital because he wanted to put an MRI in his practice. Man's name is Dr. Wong. And he had a post-op infection. Then he had another post-op infection, all of which he never had before. And he got smart. He autoclaved his own equipment. He brought in his own fluids. He took their fluids home, cultured them, grew out 3 strains of pan-sensitive bacteria. The hired an attorney. He found the invoice where they purchased the 3 strains of bacteria from a lab. I think they may have even reverse engineered it to show where it came from. And even with that evidence, he's still in the database. Something very good about here.
Doctors, people don't suspect this, but doctors who blow the whistle are very vulnerable for all the reasons that John was pointing out. And it's so important, frankly, for them, for doctors, nurses, other medical professionals to be able to speak out about issues that involve patient care, patient safety, the adequacy of colleagues who are working on patients, sometimes reporting about a colleague is very important to do.
Well,
and this is an area that I think there is not a lot of legislation on. New York has a statute that protects folks who raise concerns about protecting patients, whether they're doctors or nurses or others. But there aren't too many statutes out there that provide, protections for people in the medical field.
Actually, but this is an instance where our culture is more important. So, for example, my brother represents a whole few doctors in the double and triple booking, and the hospitals trying to get rid of them. So, get an article, big Bloomberg article last week on all of this stuff. So you get your protection not through the legal system, as Vanderbilt said a million years ago. I'm not going to sue you. It takes too long. I'll ruin you in public. you use the media to get your.
Well, I had one, a USA Today VA reporter, okay, said to me, you get me the 1,000 physicians, you don't have a national story, okay? But how do you get the 1,000 physicians? So I thought of creative ways of trying that through Facebook or whatever. But in the end, I said, I'm going to file a pro se lawsuit against the government, and then I get discovered. And I did that, it's around the same time as, well, I was actually before the MSPB thing, giving me no discovery, which I appealed. But at some point, and the agency, the VA, has been, they're concerned about my getting discovered, and which I've got none in 9 years.
I don't know if we're, or is the claim that
So, and we have other questions.
Okay,
I see we have like 7 questions online too.
Yeah, go ahead.
So I was gonna ask Tom if there were some questions you can see in the chat, because I can't see the chat to see the questions. And I know I've seen popping up that have come up about so the MSPB, the OFC, because we have in the room a lot of federal employees as well, and wanting to talk about that process and some of those rules and being able to build up those cases. So if there are questions you're seeing in the chat that you could maybe help us with right now, or Paul, I don't know if you can see the chat and some of the questions.
Yes.
Because we also get discrimination cases, people, race, religion, disability is a common one. I get a lot of people who've been discriminated against because people don't understand the FMLA and reasonable accommodation. So Tom, can you help us out? You're on.
What would be the specific question, Jackie?
So about some of the whistleblower cases that go to MSPB, OFC, if you can talk a little bit about that process. And I think there have been questions in the chat.
I've been contributing to the chat answers. As far as MSPB and OSC, these are what's available for civil service employees, but neither of them are anything you can count on. The OSC has a pretty decent special counsel right now, but he's politically cautious. They won't take on politically threatening cases that would create a backlash against their office. They work at a molasses pace, and they only really get corrective action for about 5% of people who file complaints. And that's even informal corrective action that might be very modest settlements. And I don't think it's ever realistic to expect them to be like the saviors. They've got a staff of about 100 people to enforce the merit system for close to a 2 million person workforce. They only really have the resources to occasionally make a significant point on a case, a test case that'll have wide-ranging impact on legal precedents or send a really strong message. And they've done that periodically, but they're nothing that you can count on to enforce your rights. Then there's the Merit Systems Protection Board. If the OSC hasn't helped you within 120 days, you can go to the Merit Systems Protection Board and start fresh. But the MSPB is not too much better than a kangaroo court. They don't have any judicial independence from politics. I had one case where an MSPB chair tearfully confessed to me that the White House had made her reverse their decision backing a whistleblower and rule against the whistleblower because of the national politics that were involved. And they didn't think there was anything that she could do about it except to resign, which she wasn't willing to. The day in court at the MSPB is handled at the administrative judge level, and the administrative judge corps is dominated by lawyers whose cut their teeth as lawyers for agencies fighting employee rights cases. The other main source of administrative judges is the Judge Advocate General Court, which also is their mission is to fight employee rights cases in the military. And to go after military whistleblowers. They tend to be very biased and hostile, and less than 5% of people who file for an administrative due process hearing prevail and win their cases. Unlike the corporate sector, you can't go to court and have a jury trial if you're not getting relief at the administrative level in the civil service system. That's why the legislation which passed the House last Congress, the Whistleblower Protection Improvement Act, was a desperately needed breakthrough. It would give people access to court and jury trials if the administrative process doesn't provide them timely relief. Protect them against retaliatory investigations. It would give them a fair chance for temporary relief with very favorable burdens of proof at the administrative level. This needs to be revived. And until it is, whistleblowers in the civil service system don't have viable rights. Now, I do want to put a little bit of balance into that dark vision. At the board, while only about 5% of people win their cases, depending on the year, between 40 and 50% of people get some sort of relief through a settlement of their case. The problem is if there's not much chance of winning, the agencies aren't going to give a very meaningful settlement. It'll be more like just enough to get rid of you, rather than enough to get your professional life back in order. So we've got some very serious work to do here. And I'll tell you what we do at GAP in the absence of effective anti-retaliation rights is we run legal campaigns going on the offense against the abuse of power, the corruption, the illegality, the waste, the mismanagement, the threats to public health or safety. And if the whistleblower is effective in developing a constituency around their dissent, it creates a powerful incentive for the agency to leave them alone and settle in a way that won't exacerbate the ugliness that we're effective in disclosing. But as far as formal legal rights are concerned, they're very, very weak for civil service whistleblowers. I'd say they're weaker than for any other segment of the U.S. labor force.
You have a question?
I'm a federal employee and I have a question, two, actually, one really simple one. I'll ask the harder one first. For, is there any legislation on the horizon that would prevent political appointees who are rotating in and out from adjudicating disciplinary actions, any kind of anything against federal employees? I had an adjudicator who was about 26 and he was brilliant. I'm not calling him out for his age, but he was rotating it out and went straight to the New York Stock Exchange 2 days after adjudicating. No experience really with civilian policy. And so that's one question. And the other one is when looking for remedies, if you put down that you'd like to be transferred to a different agency, do they give you any input or is it a losing battle? Thank you.
On your first question, look at the recent Bowie-Bergdahl decision in the DC circuit. You know, Bowie-Bergdahl, right? The Afghani, and Sijin Fidel is one of our great military justice litigators. The judge from the Military Court of Justice, turns out, was looking for another job. And Trump had said that Bergdahl should be executed. And the guy who was looking, the judge, was kind of looking for a job, it turns out, in the Trump. So that was an example. It's not the same case of how the anticipatory interests or something like that of the adjudicator, the road to in and outers, things like that, was taken into account. So they threw out that verdict just a couple of weeks ago. It's the Bowie-Bergdahl case.
Tom, and I think the question about being able to transfer and being able to sort of say, can I go to another agency? Because it's hostile here and I feel like I need to stay somewhere else. What's the likelihood that will happen? And how likely is the agency to let you have some input into that?
If I understand the question right, Jackie, it's what are the rights for transferring in connection with a whistleblower case?
Yes, if you want. Hostile.
Well, the Whistleblower Protection Act does have a provision for that. If you win your case, you're entitled to a transfer preference. So you don't have to go to work for the same boss you just defeated in the lawsuit, which is very welcome. It's certainly not a perfect solution, though, because you're still working in the same agency. You don't have the right to transfer to a different cabinet department or something. And your reputation will follow you within the agency. So it kind of dilutes the backlash, but it's not a solution. The other thing that I've done sometimes is after a whistleblower wins a case to be applying for jobs at other agencies. And if they're turned down due to retaliation, they may be able to get a job at a different agency, but that would be through a whole separate legal action.
Were you able to hear that, or did it answer your question?
I guess speaking to a crowd as a newer whistleblower, my EEO case, they asked for a list of remedies, and I'm thinking, what can I put down? But man, if I put down that I'd like to be transferred to a different, even within the same big agency, if I was retaliatory like they are being, man, I would put her in the corner, in a basement, and I'm wondering if that
happens. That happens actually. I mean, that's not as far-fetched. I was going to say, so I obviously left my employment where I was a whistleblower in 2013. And I really believed in another agency who I'd worked with since probably 2002. And I actually applied for a job in 2019 and interviewed with that agency and was offered that job under superior qualifications. Went through and got a wonderful job offer, argued my tour duty location, you name it, all of it, did my polygraph, and was ready to onboard. And so then an investigator showed up, and that investigator worked for my former employer who I blew the whistle on. So I called the security office and said, you have to send it to another contract company to do my investigation. And so at that time, they reassigned it to someone else. And I got one more tag at Retaliation. So an individual decided to speak on that security clearance investigation. And that's when I lost my clearance, was in 2021. So I did not lose my clearance in 2013 for the agency that I raised my hand and initially was a whistleblower for. Instead, I decided to go back to government, which was the only thing that I've ever done and the job that I loved. And I chose very selectively another agency that I knew and believed in. And I ran into the roadblock again, where someone had an opportunity to retaliate and say, basically perjured comments that have no factual basis whatsoever. And this was at the end stage after I had already received the job offer on superior qualifications, and I'd already polygraphed again.
You were already kind of cleared from the 2013.
Yeah, I never lost my security clearance throughout this whole time.
So I would think their denial in 2021 of your security clearance would be clearly. Exactly. So what happened to you?
So that job was gone. I'm sure it been offered to someone else because it was in 2020, 2021. And so I appealed to that agency, and like you, I asked for everything under FOIA and Privacy Act, and I got a beautiful letter back. But then I got more serious about it and wrote a meaner letter to that agency. And I just recently, this year in 2023, received what I asked for. And so I didn't really know why my clearance was denied. So I held the clearance since 1999. So
See this?
So I did get it. It just took me 3 years to get it. And so I got that information. And so, yeah, I would say that it's retaliation, but I haven't been very successful at retaliation in any of my cases. And so my former agency and the individuals that work there, as well as I would say the OIG and the contract company and everything, haven't really done anything about that retaliation. And so it continues, like I said, still to this day on my 10th year.
But just to finish, you're an employee, not a government contractor,
I'm a federal employee.
right? And you're going through a process,
Right, and I just filled out the initial part of the EEO form.
right? I see.
That and all that, so the remedy section was there, but looking back, when we talk about what we want to make as a legacy change, is that I had 2 adjudicators who one was really he rotated in and 2 days left, and I handed it to another political appointee, and that was for I can't talk about it, but it was something the agency was doing against me, and he had no idea about.
Do you have an attorney?
Well, yes, but
My advice is get an attorney before you fill out any forms and you go too far down the process. And if you don't like your attorney, and I'm not marketing myself because I do not do this work, but the most important thing is for you to get counsel, because so many people come to me and they've been with another firm and I'm like, I can't help you, and you just did all the wrong things. And it's too late. So
I have one.
okay.
They make you, well, what I learned was that you can only do it, you have to sign up for basically a retainer for something certain. And then they can't really give you advice outside of that unless it's super general. So I didn't know that until I got into this. I mean, I never had lawyers in my life, so.
You're not the only one. I was going to say you're not alone at all. And I think, the other thing for those of us who are government or work in classified space or contractors, that beautiful poster on the wall that you see in your company is like, call the 800 number and the hotline to report abuse, fraud, waste, and everything. And I have hung that wonderful poster in every space I have ever worked in since I've been in government. And I have hung it on the wall and put it in a presentation and instructed everyone to absolutely report anything that you see, because we care so much about it and we're going to do the right thing. And so I think now a lot about that poster and a lot about that 800 number, because it is the one that you are taught and you are almost just, it is embedded in your training from the beginning of your onboarding to call that number versus hire and talk to an attorney. And
it's often illegal. Those posters are often illegal.
They're not in the government.
No, they're illegal in the government because they are contractor answering phones, and technically speaking, contractors.
Yeah, but we take that call and we report it to the government. But I think also in private industry, another thing that I've noticed, and it's recent because obviously I am not going back to government. So I'm in private industry and we call it an anonymous ethics line. So feel free to call that anonymous ethics line anytime that you want to report anything. And under certain conditions, whatever you report might end up back to that corporate counsel. And so I think that is the thing that always kind of catches me today, is that I wish that the education existed, that individuals knew that you should find out what your rights are, what your vulnerabilities are, talk to an attorney before you actually make a decision to report something that is really egregious, that involves things that might put you in jeopardy, your job, implicate CEOs, executive leadership. There's all kinds of things like that. And I think it's really good to reach out to an attorney to find out what that road looks like before you call that ethics line that looks so beautifully anonymous, and that wonderful poster that we say it is your service to your country, your honor and your duty, and these things to report fraud, waste, and abuse. And so I think that's one of the suggestions that I would have is it's really, I wish I would have consulted with counsel prior to making.
I need to echo that real quick, if I may, just real quick.
Yeah, no, Kim has been waiting.
Sure. Go ahead.
I just had two kind of quick questions. I know that you mentioned earlier that, retaliation, anything after you've been fired doesn't count, but isn't the act of being fired or let go a form of retaliation? So
Yeah, but, and I didn't mean to suggest it doesn't count in all situations. It just depends on, frankly, what circuit you're in, what court you're in. The circuits interpret these things a little differently. Sometimes the statute is written in a way that suggests to the court that only an employee is protected. So when you're no longer an employee, are you protected? That's the question. And some courts have interpreted that yes, because it was connected to your employment, you're still protected. But other courts have said, well, no, the statute says employee, so you're no longer an employee. So if they're doing other things to you, maybe you have other remedies. Maybe there's, defamation, another issue. You may have remedies under state law. There may be, wrongful action of various kinds that you can take there. So I didn't mean to suggest that in no situation can you fight issues that happen after employment, but they can. It really just depends on what jurisdiction you're in.
well, that makes sense. So if I'm in the private sector who does HR in California, this is all very confusing for me, but there's a lot more protection there.
Yeah.
And that was the other question is, given how much injury has taken place, I don't know if that's negotiated out of a settlement, but is there any discussion or nexus with personal injury law or something like that to come back at a later time to say, these folks are going 9 years through hell. Is there not an avenue or path at all in that?
Called a passport to another country.
No.
I know, not, you had a better idea than me.
And Rich, just to clarify for us, because you said you're at HR, is the 10th Circuit decision that you're talking about limited to Qui Tam age claims or no?
Yes.
It is. So what Rich is saying is limited to if you're a False Claims Act Qui Tam whistleblower seeking a retaliation claim under the False Claims Act. It doesn't apply to, do you know what I'm saying? All content.
And it's just in the 10th, so geographically, that's how the 10th views it. So there's split decisions between different circuit courts on retaliation after you've been terminated. So it's specific to where I live and where my case happens to be and where we end up arguing. So my hope is that other cases will prevail in other circuit courts that change, or that we lobby and put in legislation that protects retaliation after we've been terminated. Because 10 years beyond, I mean, it's a long time. And I think a lot of us, it can be a very scary and traumatic thing to be sustained for that long.
Yes, so I'm gonna go to, we have Debbie, Gabby, and I just saw Ari.
Yeah, I guess changing text a little bit. Dan talked a lot about discovery, the importance of discovery. I was wondering if there are, well, as a federal employee, in my case, I find that it's very difficult, at least for the MSPB, to get the discovery that you need because they'll drag it out so long, then it's like, oh, NARA required us to destroy it, or they don't provide it and there's no way you can prove to the judge that they're withholding it because what they're withholding is, is confidential. Or, and then Tom knows in my case, being an attorney in an office of counsel, where everybody's an attorney, they used, attorney-client privilege and withheld a lot of really important documents, claiming everybody was giving legal representation to the individuals who retaliated against me. I was wondering for Tom, if you mentioned there are some 85 bits of legislation improving whistleblower protections right now. I was wondering if there's any provisions that address discovery or shore up the discovery process in pending legislation.
There is nothing on the table. Oh, sorry. No, I'm not. There's nothing on the table that would overhaul or improve the procedures at the Merit Systems Protection Board. There's been almost no congressional oversight of the board. Congress was so neglectful of this institution that we didn't even have members of the Merit Systems Protection Board for most of the Trump administration. So it's a very backward administrative remedy. And the concerns are absolutely right that the federal rules of civil procedure, while they're considered persuasive authority, they're unpersuasive in reality. Discovery is generally a bad joke at the board. Our one, and I'm not optimistic that the administrative process is going to be significantly improved. Our one escape for this is to get the same thing for civil service workers that we had for nearly the entire private sector. That if you haven't gotten timely administrative relief, you can go to court and seek justice from a jury trial.
Now, just a question, your lawyer. I was also a presidentially appointed commissioner, and the agency rules are supposed to mirror federal rules of civil procedure. So as a commissioner, I would have given you discovery. I did that in some cases. So it is, I don't begin to suggest that I would want to be before the Merit System Protection Board, but that in terms of their authority, I don't know that it's a need to modify a law. It's a need to get, whoever the adjudicator is to say, I want to do this. I mean, as a commissioner, I was shocked to see some of the decisions. I said, well, we can follow federal rules. So I just interpret it that way. I don't know. It's a need for a law change. It's a need to get a commissioner who's, adjudicated.
And I think the bigger point of your experience is that attorneys are also very vulnerable because of the privilege issues. Like it's very rare and maybe possible, for example, for an attorney to bring a False Claims Act case. Yeah. Because your professional responsibility is to that client, even when that client may be engaged in wrongdoing. And when you violate those standards, they will take your license away, or they will suspend you, or they will do other things that will prevent you from being able to practice. So doing the right thing as an attorney becomes very difficult if you're representing the wrong folks. I'm not saying that that's your situation, but and the attorney-client privilege way overapplies in corporate and organizational contexts, in my opinion.
I was even just trying to get the privilege logs to show what was withheld, the judge, and it is an MSPB thing. Maybe it's judge by judge, but this judge would not even allow the privilege logs that showed who was communicating with who, and the subject line was Debbie. And
well, that's inconsistent with federal law.
And we put them in anyway. It was just, but we put them in anyway, even though the judge said that we couldn't.
I'm going to let two more people ask questions, and then I know people have been sitting for a really long time. So I know Gabby had a question, and then Ari and Cleveland would like to maybe make some closing remarks.
And the guy in the back.
Samson, who we should introduce. Samson, why don't you please, because Tom, I think, mentioned your mom earlier. I don't know if you were in the room to hear that, but you're the SLAPP suit issue.
Oh yeah, so my mom raised some issues at work, and I eventually found out about it, and then I started a petition about it. And the hospital put up like a SLAPP suit against me, so that's what I'm doing now.
He's 15 and he has a SLAPP suit filed against him.
Jackie, go ahead. Did you have a question? I'm sorry.
Oh, yeah. My question was, what if an organization lied to someone like the NLRB, which is like the National Labor?
So what happens when they lie to the National Labor Relations Board? Or
what happens if they just lie?
Well, in general, when an investigator from an agency like the NLRB or any other agency speaks to someone to collect information for their investigation, if someone or some organization lies, that's actually a violation of federal law, even if they're not under oath. You're required to tell the truth and provide accurate information in the course of an investigation. Now, the question always then is, will the agency that's been lied to enforce the issue? Will they go after the person that's lied to them? And oftentimes, unfortunately, they do not. And so that's one of the failings of the system, is when those lies are not pursued the way they should be, and they're not challenged in the way that they should be.
Because there's a doctrine called exercise your prosecutorial discretion, and all false statements are not prosecuted. The government, whether it's the agency or the Department of Justice, is never ever going to enforce all the falsity, false statements or violations of law. They have to exercise prosecutorial discretion for a number of reasons. Resources is one, but it's not the only reason. So, and it's hard to prove. You have to be able to have the hard evidence to prove that it was a false statement.
What would be the cause of action?
I think Tom wants to say something as well.
Yes, just a quick supplement to Richard's answer. It's a felony to make a false statement to the federal government. The citation is 18 USC 1001. But the observation is very well taken. The law is not enforced. The government lies routinely with impunity in whistleblower litigation. Really, your best option is to catch them and discredit the lie, not to expect any accountability for it.
Gabby, I know you've been waiting very patiently back there.
That's fine. Thank you so much. Debbie and I shared something in particular that we are both from the OIG office or involved in OIG cases. I have pursued allegations in the past and then became part of management and I disclosed wrongdoing to the OIG. And against what I thought, because I came from the OIG community, I was retaliated against grossly. And I went to the Whistleblower Ombudsman office seeking for protections. And they are written in the policies and procedures that none of them were applied. Then we saw the ombudsman, and this is why I'm here, because it seems like, again, the nice poster says you can denounce it, but then you go to the OIG, which is the right office, and they turn their back on you. You talk to the whistleblower ombudsman, and you talk to the person, and that person sends you to number one. So it's just a loop, and there's no protections at the moment that you denounce it, you're doing the right thing. To the moment that you are faced with the first retaliatory action, you are lost. There is nowhere in the poster that says hire an attorney immediately. And that's where I think my advocacy comes from there, that there's gotta be laws to change in OIG, how they protect whistleblowers. And if I don't win my case, I will continue working towards that. And I have been working on writing some changes because I understand the OIG. I understand 1978, there was independence applied to that, to the OIG's office. There is a lacking of accountability to managers who retaliate against whistleblowers. And that has to be written in the OPM rules of federal employees, personal rules. There is a policy that I even quoted to the whistleblower ombudsman. It says right here that if a person is retaliated against, that person can ask to be moved to a different place where that person is not suffering for retaliation. I asked for that. It did not happen. I asked OSC to protect me. They will not do it. So I am to the point now where I don't have representation. My MSPB decision was issued. Lack of credibility on my part is one individual I brought to be a witness, and myself against 10 people from the agency that were testifying against my case. What do you do? if besides trying to build your credibility, you have to trust the facts. And the fact is, I became a whistleblower, excellent record, superior administrators awards, day one of year one of a recent promotion, a previous auditor with excellent record, no records of low ratings, and then I am given I was attacked in my performance rating. How could MSPB and SPB judge could not see that in the record? That this person is a perfect employee until she became a whistleblower. And
Well,
that's where
the timeline not matters, right?
No, none of that is written against in policy. If there is a person that is attacked in a performance issue, in a performance way, or based on the performance or actions that she's bringing forward, and she's followed the rule and she's following, there's gotta be something written that changes that person is immediately transferred and stop the retaliation. That person has to be in a safe environment to protect her from medical conditions. I have PTSD. I have gross issues, medical issues. So that all together, it should be, and the judge knew at the MSPB knew this, that all together is facts that are given. But again, what can you do when the credibility is based on others testifying against you falsely? But how can you prove the falsity of their statements?
It's very difficult to prove a falsity unless you're given adequate discovery to do that. And sometimes even then, if it's one person's word against another with no other evidence surrounding those issues, it's a very, very difficult thing to do. And so, I'm really sorry to hear about your experience and those that others have shared today. It's, it speaks to the inadequacy of these systems. And sometimes, to be honest with you, I will be counseling someone who's come to us like you or like others. And if they haven't been fired yet, I often counsel them, start looking for another job. Go to another place. You just need to get out of there, because sometimes fighting with the inadequacies of the system is not worth it. It's healthier for you, even if you have to start over a little bit, to get in a different place and find a place that respects you and that will care about you and that will respect your rights. Because the legal system is not the justice system. And, everybody needs to understand that. And I'm a fighter. I would love to fight for, anyone who has rights, but I have to concede that many, many times the better approach is to escape.
Cleveland, did you want to add something as well?
Thank you. Yes, I agree very much with you. And I'll just briefly say that, I read everything about whistleblower stuff for a really long time, and I came across Jackie, and I was like, this is like a really dynamic thing that this lady is doing. I sort of cyber-stalked you for a little while, and eventually we became buddies and worked on some professional testimony together. And now we have developed a professional relationship, and it's about what you guys are talking about. And Richard is the guru on sort of injuries and how to be compensated for that. And we've expanded our understanding of sort of the psychology of whistleblowing and what all of these impacts that Jackie has been educating us about, how they affect a person and their psyche and their identity, and how do we make that compensable? And we've worked with Jackie, who's done some assessments of some of our clients, and I think have helped us to enhance settlement negotiations, because we're able to sort of put a name now to some of these PTSD-like effects of whistleblowing and mobbing and isolation. And isolation that's even exacerbated, when you have to file a case under seal and you can't even talk to your best friend at work about it. And so we've been, trying to glom on to Jackie's work as much as possible to find ways not only to protect our clients from, being unnecessarily triggered, but to compensate them for those types of injuries. So plug for Jackie.
Well, and I'm gonna take that opportunity to thank you